Have you ever had an idea for a story and then found out someone else has already done it? Happens all the time. But what do you do when you think someone has stolen your story idea?
They stole my idea.
Opening disclaimer, I am not an entertainment lawyer. This is not legal advice. If you actually start dealing with real contracts and real producers on any of this stuff, get a lawyer.
I'm not a lawyer.
So, you've written a script. You've entered it into some screenwriting competitions, maybe even had it passed around a bit by potential producers. Lucky you. But nothing comes of it. Then you find out a year or two later, a movie comes out that is just like the script you wrote. What a coincidence, right? They must have stolen your idea. What do?
No, that's my idea. They stole my idea. Son of a bitch stole my idea.
You do nothing. Because I can guarantee you they did not steal your idea. And even if they did, there's nothing you can do about it. Because ideas are not copyright.
Copyright law! Copyright law!
How many films have you seen coming out around the same time that had the same basic idea? Like these, or these, or these, or these, or these,
Or these, or these, or these, or these, or these, or these, or these, or these, or these, or these, or these, or these, or these, or these, or these, or these, or these, or these, or these.
It's like everyone had the same idea at the same time. Often one of these twin movies becomes successful while the other fades into obscurity. But the core idea is the same. Did one of them steal from the other? No, it just happens. Not just sometimes, but all the time. This is why, as a rule, studios and producers don't read unsolicited screenplays. Aside from being overwhelmed by mediocre scripts, they don't want to run the risk of being sued, in case one of those scripts has the same basic idea as something they're already developing.
Oh, sorry, I do not read unsolicited manuscripts.
Now that's not to say it's never happened, it has. There are a few times when it's been alleged a script for a movie was stolen and it's actually gone to court. But here's the thing. You cannot copyright an idea. What you can copyright is the tangible expression of that idea in a fixed form. The more original and complete that expression, the more copyrightable it is. But it must be in a fixed medium of expression. That is, a written document, an audio or video recording, a photo, a roll of film, a sculpture or painted canvas. Something real and tangible that others can see or hear. So, when a movie is accused of stealing someone else's idea,
They stole my idea.
it's not the idea that's important. Ideas are a dime a dozen. It's the details that are important, the specific expression of that idea, the dialogue, the words on the page, or at the very least, the specific sequence of events and actions and characters and behaviour, of locations and design, of shots and composition that make up the story in this film. Not just a few coincidences.
Coincidence?
Or using the same basic tropes of the genre.
That's the genre.
Or even things that draw from the same influences.
Who are your influences?
But wholesale, identifiable plagiarism.
It's theft. And theft makes thieves.
This is why in the movie business there is a thing called chain of title. A way of tracking every iteration of a story during its development. Every writer who may have been connected at some stage, going back to the original novel or newspaper article or comic book that started the whole thing off.
Here's what started the whole thing.
And it's why, on every contract for a spec script, a writer must declare that this is their own original work.
I wrote it.
Think about it. If a producer sees an original spec script they like, well enough to want to make it, but they think it needs a rewrite, the first thing they are going to do is option or buy that script from you. And then they will either ask you to rewrite it according to their notes, or hire someone else to do it. Either way, the chain of title starts with you. And if an unscrupulous producer did not do that, if they stole your idea, but wrote a whole new script based on that idea, you have no recourse. It's not your script. If they produced a film using your script, changing it very little, and did not buy that script from you, or come to some other arrangement with you, then that's illegal and they're a thief.
It's theft.
And I'm not saying that doesn't happen, but it is so rare, so unusual, that the only way to safeguard against it is to never show your script to anyone. Then it can't be stolen.
Never show anyone.
Which kind of defeats the purpose.
Derivative works.
If your script is based on some previous property by someone else, a novel or a play, for example, it's a derivative work. It is derived from that other work. And if that other work is still in copyright, and you do not have the rights to it, then what you're doing is technically illegal. I say technically because you're free to write whatever you want. You just can't turn it into a film and try to sell it. So, writing a derivative work based on someone else's existing copyright is either A, a personal writing exercise, which is fine. B, an adaptation of a work you have secured the rights to and likely paid some money to the original copyright holder to get those rights. Or C, an adaptation of a work you have not secured the rights to, in the hope that some producer down the track will do that for you, if they like your script well enough. Now, this third option has been known to happen, but don't count on it. Most producers will ask you up front if you have the rights, and if you don't, they'll pass. Because getting those rights can be a real headache. And they've got a pile of other scripts they can turn to that don't have this kind of baggage. Option D, of course, for derivative works, is to base your script on something that is in the public domain.
Copyright expired.
Copyright does not last forever. Currently, it's 70 years after the death of the author, but that varies from country to country and is different for corporate work-for-hire copyrights like most movies. And the laws have changed a few times, especially in the US, so it depends when the original author died, what country you're in, and what kind of work it is.
I'm lost.
Now, a work can be public domain in one country and still in copyright in another. Or the original novel may be public domain, but its most famous derivative work is still in copyright. So it's worth double checking before you dive into doing an adaptation. But assuming it really is in the public domain, once the copyright has lapsed on a work, anyone is free to adapt it.
Copyright expired.
And this happens to a host of new works every year on January 1st. Check out the Wikipedia pages for a list of works recently lapsed into the public domain. When you do adapt something, anything, public domain or not, it creates a new copyright specific to your work. And anything you do in your reimagining that is different from that original source material is your new copyright.
It's mine, you understand? Mine! All mine! Get back in there!
Now this is where things can get very confusing, and why that chain of title I mentioned is so important for tracking this kind of stuff. To avoid any issues, very often, a producer will pay for rights they probably don't need, just to be safe. Which brings us to...
Lifeguards.
Sometimes the story you want to tell is a true story, based on someone's actual life.
I have rights too, you know.
A biography of a famous person, or a compelling incident from the news that actually happened to someone. If the person is some historical figure, long dead, and the sources for your story are all historical record, then it's in the public domain. And you can do whatever you like.
Go for it.
If, however, you are basing your script primarily on a book that some historian has written, you should get the rights to that book. Their research, their conclusions, and their characterizations are their original copyright, even though it's a non-fiction retelling of history. If that book, however, is just one of many sources you use in your research toward writing your own original take, then you're okay. Probably.
Not a lawyer.
If the subject of your story is a celebrity who has recently passed, this still applies, provided you stick with stuff that is on public record.
We got the life rights? It's not Janie Jimplin anymore?
Bear in mind, though, they may still have works that are copyright, so you can't use them without a license. And, more importantly, family estates and relatives still living who have a vested interest in the legacy of their famous grandfather, auntie, whatever. This is where securing life rights can be so important.
I have rights.
If you have the support and endorsement from the subject's estate, then not only do you avoid any potential legal battles, you can get the rights to include their copyright works in your film. And, most importantly, you can get personal insights from the family and friends that are not in the public record. Likewise, with stories about people still living, famous or otherwise, if the story is on public record, like some big news story about a dingo stealing a child and the insanely Kafkaesque legal battle that followed, you can write a version of that without life rights of the people involved. But it's always best to get life rights if you can, for the reasons I mentioned before, and, frankly,
it's the right thing to do.
But this can be a double-edged sword. While life rights give you access and permission to tell this person's story, it can also restrict the kind of story you're able to tell. Many authorized biographies skirt around the darker or more unsavory sides of a subject's life, even if it's well known, to paint a more agreeable history. If your subject's story is not widely known, perhaps someone you know personally, you either get the life rights,
I have rights too, you know.
or fictionalize it enough that it can no longer be recognized as someone's true life story, inspired by the truth.
Not without my anus. Based on a true story.
But what about fair use, I hear you say?
Fair use.
The concept of fair use is that you are entitled to use someone else's copyrighted work without license or permission under certain special circumstances. These are commentary, search engines, criticism, parody, news reporting, research, scholarship. This channel and the clips I use in my videos would count as commentary or scholarship, since the main focus here is education. The concept of fair use was a convention for many years until it became law with the United States Copyright Act of 1976. Now, in Britain, Australia, and other Commonwealth countries, this is called fair dealing rights. Similar, but not exactly the same. For example, in Australia, fair dealing exceptions from the Copyright Act of 1968 and the Amendment Act of 2006 are research and study, review and criticism, reporting the news, legal advice, parody and satire, with some exceptions. Most countries have a fair use or fair dealing law, but not all, and there are nuances I'm not going to get into here. Now, this rubs both ways, of course, meaning someone else can use your copyrighted work in their stuff if it meets any of those listed criteria. You may not be happy about that, but the fair use loophole should apply to everyone equally, even musical acts from the 70s and 80s.
Beatles, Led Zeppelin, Pink Floyd, Jimi Hendrix, Prince, Eagles, Fleetwood Mac.
And if you're wondering why the practice of musical sampling isn't on that list, that's because after a number of court cases, sampling is illegal in pretty much any situation without proper licensing. So, if you're going to use someone else's copyright stuff in your own works, make sure you license it, or have a valid fair use case. Now, there's an easy test for this. It needs to do one of these 5 things. 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Meaning, how much are you adding, and is it of value beyond the copyright work itself? 2. The nature of the copyright work. Is it fiction or non-fiction? Is it in the public interest or of historical significance? 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. How much of it are you using? And if it's just a small part, it's less of an issue. 4. The effect of the use upon the potential market for or value of the copyright work. Does your use of the work affect the copyright owner's ability to make money from it? Related to this is the concept of sans-faire, which means you cannot copyright tropes that are part of a known genre. So, even if two stories are very similar, that may be because they are using the same genre tropes. You cannot copyright a genre.
Hey, mockumentary is not a trope, it's a device for storytelling.
Protecting your copyright.
So coming back around, if you have an original story, what can you do to protect your script? Not your idea, but your script. There are three things basically. 1. You can register your script with the Writers Guild or the US Copyright Office. Now, while helpful, all this does is prove that you had that finished script on that date, and they can verify that. They can't attest to its originality or that it predates some other script with the same idea. This is only useful if it ever goes to court or guild arbitration, but it's something. Now, to be clear, your screenplay is copyright the moment you write it down. You don't even have to put your name on it. However, it is a good idea to put your name, the copyright symbol, and the date on the front page. You don't have to register your script with the US Copyright Office to ensure copyright. You already own the copyright just by making it. But many recommend that you do, because if you ever decide to sue someone for breach of copyright, you need to prove it. And you need to prove that you wrote it before they did. The best way to do that, in the US, is to register your script with the US Copyright Office. If you then decide to sue someone for stealing your script, it is a legal requirement in the US that it be registered with the US Copyright Office as a proof. Your lawyer will expect to see that. But it is not essential for establishing that copyright. It's just a way of proving it. 2. Make sure you only show it to people you can trust. Now that can be hard to tell sometimes, but any producer, actor, director interested in reading your script ideally should have some kind of track record. Look them up on IMDb. Meet with them and see what your gut tells you. Give them permission to pass it around. The more who see it, the better. Now, NDAs are pretty useless.
It's a boilerplate NDA.
But having something in writing as early as possible is good. If they express interest in your script, they should offer to option it or give a letter of intent. It's not about the money. It's about establishing that chain of title. And when things start to get serious,
Talk to a lawyer and get a professional opinion.
Side note, there are lots of indie producers looking for scripts to make, offering no money or deferred payment, which means no money. Most of them are just like you. People with limited resources trying to break into the business. My advice? Unless you know them personally or can get to know them, don't bother. You may as well make the film yourself, which is always an option. 3. Get an agent. Easier said than done, I know, but an agent will be able to send your script to producers you can't on your own. They should be aware of what people are looking for and what opportunities are out there. And they can help ensure only legit people read your work. But remember, your idea cannot be copyrighted. And no serious producer is going to steal your script. It's just not worth it.
It's not worth it.
And if, despite all this, someone does steal your script, first, are you sure? Better be sure before you start suing people.
I'm suing, you hear me? Suing!
And if you are sure, do you really want to fight that battle? Nowadays, it's far easier to shame someone than to sue them. And even then, it could backfire on you.
Sometimes these things do not go as planned.
My advice, in the highly, highly unlikely event it does happen to you, don't go public. Just vow never to work with that person again and let it be known privately that they cannot be trusted. Don't worry, the word will get round. Just focus on writing your next script. Till next time, I'm Phil Moore. Chookas.